According to the impugn award passed by the learned tribunal is hereby set aside to the extent that it has interfered with that four, charge number 4. So it is sent back to the authority to consider whether they want to impose any penalty. 21 to 23. Accordingly, this court directs the principal secretary of the government of Assam, Panchayat and Rural Development Department to cause an inquiry as to why the above three markets have been settled at such low rate. And the validity of the existing settlement of the markets will depend upon the inquiry.
Well, you're an eviction case, Milad. So I have highly studied. So I think there are to move it tomorrow.
Eviction, not in this bench.
It people. Because I'm praying for listing of this matter tomorrow for motion live. My lord, I was attached to the PSO, my lord, and this honorable court was
You attached to PSO?
PSO was attached to me, my lord. And this honorable court on the earlier round of litigation was pleased to direct the state secretary review committee to make a fresh
This is not this bench. I think the bench 3.
No, my bench four, earlier it was the bench 4 matter. It's regarding my PSO.
No, this is PSO, this is different. PSO, I don't think is a bench 4 matter.
Earlier it was before bench 4.
I doubt it's before bench. Uh, huh? Bench 5. Bench 5.
I'll make it. Briefly outline.
May I please, Your Lordship? I'd like to mention Act number 11 of case.
Yes.
I'm for respondent number 129, Lordship.
Yes.
We need 2 weeks time to file our affidavit. Item 11.
11. Who's for the petitioner? Okay. Any objection? Mr.
MK Das, Lordship.
M.K. Das appearing for the respondent number 5 to 9 is granted.
1 to 9, Lordship.
1 to 9 is granted. How much time?
2 weeks time.
2 weeks time to file affidavit in a position. This is the matter.
Dear Dear.
May please the Lord. Lordship, I beg to mention item number 10, 9 and 10, my lord.
Yes.
Take it consent from the other side. 9
Yes.
and 10.
Yes.
And put a respondent. Hello, can you take up the matter after the vacation?
I am for a
Has contract been terminated?
Yes.
Is there any arbitration clause?
But some of the payments are still things, my.
Huh?
Some of the payments are still things, my.
Maybe, but then you go for arbitration. You have forfeited your performance guarantee, performance security. But most probably you have. So all those issues will have to be taken up. Measurement. Yes, but
Pick up after vacation, review vacation, final for final.
Mr.
As has the recovery.
S. Hazarika also for the petitioner says that the matter may be adjourned. Good stuff. Mr.
K. Kolita.
K. Kalita appears for the respondent. The matter pertains to termination of a contract. Good stuff. It is also stated by the counsel for the respondent that there is an arbitration clause in the contract agreement executed between the parties. This is the matter on give it.
May please, your lordship, for listing day after tomorrow, your lordship.
What is the matter about? New case.
Lordship, lordship,
Is it a new case?
new case, lord.
Regarding what?
Regarding one-time settlement, OTSP, lord,
One-time settlement of what?
of loan account. Lord.
New case.
New case, oblige, your lord.
Please, Your Lord. Item number 16 and
16 and
17.
yes.
Adjournment slip has been moved.
Huh?
Adjournment slip has been
Okay, yes. On behalf of Mr. Kejriwal,
No, I'm for APTCL.
Huh?
I'm for APTCL.
On behalf of
APTCL.
APTCL, right? So have you, who's for the other side? You're for the petitioner. So, okay, right. A judgment prayer has been made on behalf of the counsel for the APDCL on the ground that
Sorry, ma'am.
he's unwell, he's in America. What happened? Why do you want a judgment?
This is out of state.
On the ground that is out of state. The same is not objected to by Mrs. S. Kejriwal. Accordingly, release this matter after the Bihu case.
But it may be posted in May.
Maybe
Any
accordingly, release this matter in the month of May.
Your lordship, for the consent of other side, I take to mention item number 3, kindly attend to the
Item
item number 3.
3. Item 3.
I am Sanjay Bhakti.
Why do you want to adjudge this matter?
Personal difficulties of
Huh?
personal difficulties of
Personal difficulty. Okay. Right. A general prayer has been made on behalf of the petitioner's counsel, Mr. P.K.R. Chowdhury. Accordingly, release this matter after the vacation. You've got a good case. I don't know why you're doing it.
I take to that for the pending petition. Next market, contact with all level.
Huh?
Contact.
No. It's next after that.
My please, Your Lordship. I beg to mention for listing of a writ petition, the matter pertains to settlement of market. And the matter was last listed on 7/12/23. And
Difficult.
any day after vacation, means
After
in the month of December, it was listed, sir.
Okay, give it.
Deeply obliged.
May I please, Lordship? Lordship, pending writ petition, Lordship, it needs to be listed, Lordship. It's the
After
the
vacation. Give it.
Obliged.
Huh?
Similar class, Lordship.
Give it.
Not take.
Yes, Bihu. We'll give you a date between the Bihu vacation. Huh? Huh?
I did.
Please, Your Lordship, I beg to mention one item for withdrawal.
I beg to mention item number 18, Lord.
18.
18.
1-8. Ah.
Lordship, this matter may kindly address.
Why?
Lordship, my senior is out.
Who's the senior?
The MA Sakai.
Who's for the other side? This matter has been pending for a long time. Okay, right. A German prayer has been made on behalf of Mr. M.A. Shamit. Now for the petitioner. Any stay order in your favor?
Lordship, I don't.
Have you spoken to the other side?
Lordship, my senior is already.
Huh?
Yes, sir.
What is your name?
I don't think. 1.
18 is regarding that Kazi who is working beyond his jurisdictional area. Problem is the other side is not here. What is your name?
Check up.
Mr. Sheikh Abdullah, appearing on behalf of Mr.
MA Sakai.
M.H. Ahmed. Submits that he has taken the consent of the other side for adjournment of the case. Accordingly, release this matter after the Bihu case. So, your name is very famous name. So that's why we allowed your friend. Next.
For the section of my client.
Okay, Mr.
As to the
Yes, Sutradhar, learned counsel for the petitioner, submits that as per instructions from the petitioner, he wants to withdraw the writ petition. Mr. S. Bora appears for the SSA. The writ petition is accordingly dismissed as withdrawn.
Right.
Same.
Same.
Same out here it will be Mr.
You should.
U. Sharma appears for
NRD.
PNRD department. Huh, same.
Yeah, please, sir, question. Of course, my lord, there are two issues also we can draw your attention. One is that jurisdiction part, and other is Section 8 of Arbitration Act, party may refer to arbitration. But appointment of arbitration is under Section 11. There is a judgment I got it, my lord.
No, I'm not going to go in appeal. You can, this cannot be appeal. Only question I want to answer is whether the NLCT was approached first or this?
No, this spoke first, then NCLT. my lord. That is the what they have misled the court, my lord.
Okay, okay. So that was not known to us.
Yes, my lord, because the junior was there.
And what was the other thing?
Other thing was jurisdiction part, my lord. If lordship see page 62, my lord, per moment,
Ah.
my lord.
62.
Page 62, my lord.
Have you given a copy of this to the other side?
No, my.
Why? This is a review.
It was there, my lord.
Huh?
Their outstation, my lord, then put it. I will serve a copy, my lord, if lordship side.
Okay, 62, yes.
Lordship may, after the arbitration clause 11.11.
Huh?
Governing law and jurisdiction, the agreement shall be governed by the laws in India. The courts at Guwahati, Assam shall have exclusive jurisdiction over all the matters arising out of.
So basically you're saying that the seat of arbitration will be here.
That's correct, my lord. Secondly, my lord, all the jurisdictions so far, this matter, anything comes up, it will be Guwahati. They have opposed NCLT Kolkata. NCLT is here also, my lord. They could have opposed here, and they have agreed to this agreement, my lord, signing the.
Okay, anyway, right. Heard Mr. J. Roy, learned senior counsel for the review petitioner, who submits that the impugned order dated 9/2/24 passed in ARB P2 of 2023 should be recalled, in as much as the respondent had not given the true facts before this court. So we submit that ARB P2 of 23 had been filed
On 13/12,
on
2020,
13/12/22
2020,
while they had approached, while the respondents had approached the
NCL,
NCLT Kolkata on
12/7/2020,
12/7
2020.
to 2023. He further submits that in view of the above and the fact that and in view of clause 11.10 and 11.11 of the contract agreement, the matter was to be heard in what?
And next point is that, my lord, that section 8 is the party to be referred for arbitration, but 11 is the for appointment of arbitrator, for which we filed this.
That is a different issue.
Right.
Issue notice unreturnable in 4 weeks. Review petitioner take steps for service of notice upon the respondent's number
1 and 2.
1 and 2 by registered post secretary within
One-
2 days.
2 days.
Within 2 days. What about Dusty? Is it required? No need.
No, my lord, they are outside method.
List the matter on. Let me. Or before, what do you want? Then let have to come for the. When do you want? Before that?
No, maybe after that also, my lord. Let it be 13th May, my lord.
13.
Oblige.
So this architect matter earlier, Lordship, please
No.
to reject it.
Huh?
Lordship, please to reject it. Lordship, earlier, Lordship, so it has come before your Lordship. The humble prayer, Lordship, that one four issues has already been released on sale in the.
Release on bail on what ground?
The ground I understand, Lordship, that, and further, Lordship, the trial is yet to begin, Lordship, because one of the equity.
Mr. Counsel, the heroin was seized from whom?
Lordship, from my
From you,
law,
you and the other person.
Lordship.
What do you mean? So the reason that the other person was released was on the case of Tufan Singh.
Lordship,
Then-
statement of co-accused.
That's okay, is inadmissible.
That's very well, I understand, Lordship, but the trial is.
I think the court order, there's something wrong in the wording. Granting bail, there's something wrong in the wording. If you come to page 30, page 63, para 13. Please read para 13. Yes,
Yes, my, pair 30, chapter 4 in the case of
Tufan
Tufan Singh versus the state of Tamil Nadu, reported in 2021 461, has observed that the statement of the co-accused, recorded under section 67 of the NDPS Act 1985, is not yes, my, yes,
that not should be there.
yes,
That should be there's a mistake.
yes, very fine. Yes,
So if it was is not
yes,
inadmissible, then he could not have been allowed.
status is
Sorry, Mr. Counsel, no case.
So, Lordship, teacher, Lordship, kindly call for the scan copy, Lordship, and because.
Nothing to do. You show me, you see, when the heroin has been seized from your possession, what more do you want?
So, Lordship, the,
You see, it is your duty under section 37
Yes.
to, because the burden of proof is upon you to show that you are innocent. So show me.
Lordship, and one more thing, Lordship, the delay, Lordship, will kindly see, Lordship.
Delay, how many?
No, no.
When was the seizure made?
No, charge sheet was, Lordship, submitted on 13/5/2023, Lordship.
Ah,
Now,
13.
1 year, almost 1 year, Lordship, 1 month left. The trial is yet to commence. Charge is yet to not framed.
that part minor is not clear for
Okay.
that petition minor. That for that minor,
Kindly call for the
but
scan.
minor as part.
Huh? But how will that help you?
No, it can be, Lordship, the 1 year has done, almost 1 year.
So how will that help you 1 year?
So the delay, Lordship, that the trial is yet.
Exceptional.
If you, for 1 kg of heroin,
Half, my position, half.
you have not even you have not even been there for half of the period.
No,
Not even for 5 years.
but,
Yes, so that will not apply to you anyway.
Lordship, later scan copy come and Lordship may
No
put some
case.
observation, Lordship, to.
You can try your luck in Supreme Court.
No, Lordship, that.
1 kg of heroin, Mr. Yeah. If you can show me that you are not involved, or if you are in the same boat with this Majibur Rahman,
That I'm not, on other part, Lordship, the delay part is also there, Lordship, that the.
delay
1
part, then how long have you been in jail? How long have you been in jail?
Lordship is, 1 and, Lordship, 498 days.
498 days, not even 2 years.
So at the trial has not.
And what is the minimum sentence? 10 years.
10 to 20 years.
10 years.
10,
10 years.
20.
10 to 20. Okay. Heard. Mr.
Yes.
Excellent. So learned counsel for the petition. Also heard Mr.
MP Goswami.
MP Goswami, learned additional PPT. The petitioner has approached this court for the second time for grant of bail on the ground that the co-accused MD Majibur Rahman, alias Mujibur Rahman, has been granted bail by this court by order dated by coordinate bench, by order dated 5/1/25, 5/1/24, passed in bail application number 2479/2026. Next paragraph. The petitioners counsel subject that as the co-accused has been granted bail, the petitioner should also be granted bail. He further submits that while charge sheet has been submitted on
13/5/2023.
13/5/23, the trial has not started. Charges have been framed.
No.
He submits
Because,
that charge
only because one accused is still absconded.
13/5/23, charges have not been framed till date.
That part may be added, also there is still absconded.
Full stop. Inasmuch as, who is absconding?
Another co-accused, not
Another co-accused is there.
Inasmuch as the third co-accused,
Mohammed Hussain Ahmed. At page 54 now. Page 54, last part of the charge sheet. Last part of it, above last line of it. Mr. Hussain Ali is still absconding and hiding somewhere, so I pray honorable court declaring a absconder to issue arrest.
how many co-accused are there?
There are 4 persons.
Oh, that's not third, whatever. As much as the fourth co-accused, MD Hussain Ahmed, is still absconding. Mr.
FD.
The additional PP on the other hand subject that no case for bail has been made up inasmuch as
Article 1.
the co-accused MD Majibur Rahman has been released on bail on account of the heroin having been recovered only from the possession of the petitioner and
The
Other court.
other co-accused.
And
From who it is recovered.
so there are 4 of them here. Huh?
He is Oduda.
Udud Ahmed, Udud Ahmed, Abud Ahmed, and
Obud, A-D-U-D, Oduda.
and
Three
That
were
one case
arrested by the one place.
Page 54 lot.
from Adud, A-U-D-U-D, Adud Ahmed. Accordingly, the portrait bench in bail application number 2479 of 2026 had held that as MD Majibur Rahman had been arrested on the statement made of co-accused, which was inadmissible as evidence, the said Majibur Rahman was released on. I have heard the last counsel for the past. The facts of the case show that 1 kg of heroin had been seized from the possession of the petitioner hearing and Adud Ahmed. The appellant, no, the co-accused MD Majibur Rahman had been arrested on the basis of the statement made by the co-accused. The portrait bench of this court, by order dated 5/1/24, passed in bail application 2479 of 26, had granted bail to MD Majibur Rahman in terms of the judgment of the Supreme Court in the case of Tofan Singh versus State of Tamil Nadu, reported in 2021 4S61, wherein it held that the statement of a co-accused recorded under section 67
67
of the
NDPS.
NDPS Act is inadmissible as evidence against the court. The next paragraph. The petitioner hearing had applied for bail earlier, while bail application number 3617 of 2020. And the same has been rejected by order dated 9/10/2020, page 58. On considering the provisions of section 37 of the NDPS Act. Comma, this court does not find any reason to grant bail at this stage.
Yes.
Accordingly, the bail application is rejected.
Much obliged. Much obliged.
Public. Lordship may kindly pass over the matter for time.
Lordship, then, at-
4 and 5,
no, madam.
Item two.
item 2, yes. You ready? Item 2.
No, Lordship. Kindly pass over the matter for time.
4/5/20.
28 and I as it had told.
Look at your application. Look at your application, madam. This is not the way to ask for amendment of a writ petition. You've got no idea of how to write an application in appeal.
Okay, only the prayer portion, so I did not go.
No, madam. You see, when you make an application, you have got to make it one of the paragraphs. That this is the prayer that you want to insert. It has to be one of the paragraphs in the application. In place of the existing prayer, this should be the amended prayer. So that has to be there. Now, what is the amended prayer? I do not know.
But actually, there is no amendment. The prayer by mistake, I don't know. After the draft copy was checked and final copy was, by mistake, it got deleted. Some portion of the prayer got.
That's what I'm saying.
deleted.
That's what I'm saying. It has
So
to be
it's
there.
just the only few lines, which should
What,
be
what,
there.
what are those few lines has to be there in the paragraph of your application, madam. It has to be in your pleading. You cannot make submissions beyond your pleading. You cannot ask for amendment of a writ petition for pleading in the, without there being pleading in your application. Now you see, supposing I want to add that person is very smart or very stupid or whatever. In paragraph 25, I'll have to put in the application. Paragraph 25 may be replaced or the following words, the following sentences may be added. So, but here there's nothing, neither in your prayer also.
I just mentioned it, the initial point itself, that an application requirement. for
You have submitted
prayer
a,
portion, only the prayer.
you have submitted an application for amendment of plain.
Prayer portion.
Madam, this is a writ petition. There's no question of plain. There's a writ petition. Plaint is in a suit.
That was by mistake, maybe. So
There is a plaint, there's a written statement, there is a replication maybe. But in a writ petition, there's an affidavit. There is no written statement. So I mean, basic things like that have to be
Small
there.
small words, but it matters.
Naturally,
Simple words, but
Actually-
it matters.
naturally. You cannot file a writ petition saying that this is a suit for something. You have to say that this is a writ petition.
Okay, bye.
So what is this? This annexure. This annexure,
Annexure
B.
is not required actually. Annexure is.
annexure B is the amended writ petition.
petition.
Amended writ petition.
It has to be submitted subsequently. If it is allowed, then it has to be.
You will allow what is there.
In case of allowing this IA, then it has to be supplied.
We'll allow whatever. But please, try to, please, if you don't know how to make it, look, there's no shame in not knowing. Don't feel embarrassed
Not
about
because-
asking.
It happens that some words, like so many draftings are there. It gets overlooked.
No, madam, there's nothing called overlooking here. The
Not
very,
even my.
the very manner in which you have drafted it is not even a amendment application. Neither is it in the prayer, neither is it in the pleadings. It's only you have made an annexure of the amended writ petition. Anyway, but please ask around if you don't know. You see, there's no shame. Because even as a judge right now, when we are unsure of a lot of things, we ask around. We read, we ask around, and then we try to come up with what is there. But then you're just taking a risk, doing whatever you feel like. That's not the way. Anyway, I don't think you have any objection.
No.
Okay, right. This is not the way, huh? I, Miss
Ember.
Embora, appearing for the applicant slash lead petitioner. Praise that the prayer portion of the writ petition may be amended in terms of annexure B of the application. Mr. K.K. Parashar, learned CGC, appearing for the respondent, submits that he has got no objection to this. So accordingly, the prayer for amendment of the prayer portion of the writ petition is allowed in terms of annexure B of the application. The applicant shall submit the amended writ petition before the registry of this court within
Make it public.
within 2 weeks. This is the matter after 2 weeks.
But it's not 2 weeks, because
Yes, you can do it within 2 days also.
yes, but
Within 2 days.
it is just that new financial year has started, Lordship, and tenders are being floated now. So again, I am the loser.
So, madam, so
I
it depends.
understand.
When will you file? You have got to first file.
Lordship, two will be long.
For 2 days.
Yes, Lord.
Within 2 days.
Lordship.
Okay.
Okay.
Then this is the matter. In the main case, you write 4 and 5. What is 4 and 5?
In 4, if
Four.
IA in
No, I is in 5.
9 and 4.
in
4, right? In view of the order dated 2/4/2024, passed in IAC number 990 of 2024. The petitioner is to submit an amended writ petition with the amended prayer. This is the matter. When? Next Monday?
Next.
This is the matter on Monday.
regarding the second petition, I have to file,
Second writ petition?
I have no 5, I have to file affidavit, but it has been sent for 15 people.
986, Lordship.
Huh?
23.
Item?
Number 5 is the second,
Item number
number
5.
5,
Okay, item 5, huh?
Lordship,
I'll-
here the
so-
case
so-
is that we have completed the
No,
work.
in WPC, right? In WPC, then in the main case, make a separate paragraph, second paragraph. In WPC 986/2023, Mr. KK,
draft has been sent for 15,
Mr. KK Parasab, he submits that the draft affidavit has been set for vetting, and the same will be filed within 3 weeks.
3 weeks,
This is the matter of 3 weeks. No, don't say that. Don't say this is the matter of 3 weeks. Just say will be submitted within 3 weeks. That's all. And we have the other matter you list the matter on it.
Tag, they will come.
They are taxed.
This is the matter on it.
Again.
Public.
So that's the earlier one, I is accordingly disposed of. Better?
The petitioner is seeking, my lords, realization of some payment. No, we are just,
30 lakh,
my lord, he
forest
was in-
royalty, 30 lakh.
Yes. So, my lord, the whole basis of his case, he says that he has paid the Mizoram authorities.
Ah,
So, my lord, let them implead once. If they come and say that this is genuine, he has paid, it's source, we'll give.
where, which one is genuine? Page,
Yes. My lord, Hezari Salam, page 27, my lord,
page 27.
page 27.
This is government of Assam.
No. Mizoram. Page 26, sir. 26. 26A, original, my lord. So certified by what? Then, my lord, certificate. Certificate was issued by the DFO Collective, my lord. The lordship will find.
No, it is not from the, CFO policy. It is from the Bhairabi range officer, RO.
Under collective forest unit. Then, my lord, your lordship will find.
The
It was
sum of rupees 6 lakh,
6 lakh.
sum of what? River boulder.
Yes, my. Repair board, sand repair, chief, and
River boulder in Bhairabi. Boulder is usually taken from Assam rivers. Because we don't have good boulders there. Sand, so okay. Sand, so can be done.
then, my lord, your lordship will find. Page 30, my lord. Page 30, my lord. This is in pursuance of letter dated, my lord, earlier page, my lord, page 29, my lord.
No, they have been used for construction of what work? For construction of works in Assam.
My lord, yes. Let him impeach the Mizoram authority. The veracity of that statement can be checked. If they say it's okay, then we'll give it. My lord, they have already said, my lord, better was confirmed by the, my, kindly see, my lord, page 29, my lord,
Yes, page 29, yes.
page 29.
Yes.
When he submitted the, forest royalty clearance certificate, then the, executive engineer verified the same from DFO scholarship, my lord, whether it is correct or not. And DFO by letter
is.
dated.
So you see the problem is now they are disputing this document.
No, my lord, they cannot dispute, my lord.
Why?
But when the authority, my lord, authority said that yes, we have received the payment, my lord, by such and such. Then another part is that part. The law is well set at
There is just a minute. Certificate towards favor assessor for the application and your contractor. Very interesting.
in
Very interesting.
this regard, my lord. And so far, law is concerned, my lord. It is well settled in Muslim Ali, my lord. In Muslim Ali's case, my lord. My lord. It was held that the government cannot go to the source until and unless there is a specific clause in contract agreement, my lord. Government cannot go to the source from where the materials was procured, my lord. It is settled and in all subsequent cases, my lord. there was no such clause in contract agreement signed. They even cannot ask the petitioner from where he collected the money. They don't know.
Very wrong.
You see, now, you see, there is a division bench judgment
Yes.
subsequent to that.
Yes.
That is, I think Justice Sandeep Mehta and,
Yes, madam.
So we can ask for the source.
They can ask for the source and I have disclosed the source, my lord. So, and my lord, in one judgment, my lord.
no,
later
no,
judgment-
but this, you see, the problem is, the thing is that they want to know whether you have really paid royalty or not. So you, according to you have paid to the Mizoram government.
Yes, my lord.
We, now they are saying they are disputing whether that document is correct or not. So you make them party, how does it, then they'll clarify.
That I do not have any problem, my lord.
Make them a party. File an application, make them a party, let them file an affidavit. End of the matter.
Let the secretary implement. Government of Mizoram.
Forest Department.
Otherwise, my lord, it is a totally politically motivated case, my lord. They also know this, my lord. Otherwise, my lord, authority also know that he has collected the material from the Mizoram, my lord. There is no dispute. Otherwise, my lord.
I do not know, na.
Yes, yes.
Because the problem is you two know, I don't know.
It will-
And I am going to pass the order. Unless I am satisfied. Now, to be satisfied, how to, we have got to know the fact.
And one letter, my lord. Kindly, one, my lord, page 40, my lord.
Page 14, 40.
40. There is no problem for the PWD department. The contract was between me and PWD, my lord. How, my lord, forest has come?
We are the custodian of the resources.
But we.
Minor minerals.
No, my lord, one thing that I fail to understand in this. When royalty will come, if I procure material from him, then only for forest royalty will come. If I have not procured from,
No, their case is basically this. Basically, they are saying that in all probability, you have taken the minor minerals from within the state of Assam, pretending to take it from Mizoram. That is what they say.
my lord, agree.
That's what they are saying.
My lord,
In
cannot-
black and white.
cannot-
So we just have to see this. We just have to see the Mizoram thing because let them say, come in affidavit, let them say, clarify.
but only page 40, my lord.
Before. Yes.
Unnecessary delay, my lord. I have no problem to.
Maybe, but so what? Money is money. It is not going to get lost. If you are entitled to it, you'll get it. Right. Heard. Mr. A.H.M.R. Chaudhary. You see, this is a forest department, the government of Gujarat. They will pass an order, they will do it. It's not difficult. Heard Mr. H.M.R. Chaudhary counsel for the petition. And Mr. R.R. Goyal counsel for the. Mr. R.R. Goyal is there also? No. R.R. Goyal for the PW. Also heard.
For B, go for
Acha, Mr. B. Goyal for PW.
B, go for forest.
Last time Mr. R.R. Goyal was there. Then Mr. B. Goyal for PWD. Mr. D. Goyal appears for the forest department. The matter pertains to the claim of the forest department for payment of forest royalty amounting to rupees 30 lakh. So, on the other hand, the petitioner's case is that for the minor minerals have been brought into Assam from Mizoram and the forest royalty for the same has been paid to the office of the range officer Bairabi, B-A-I-B-A-R, B-A-I-R-A-B, which is under the office of the DFO Kolasip, K-O-L-A-S-I-P. This court is of the view that to that the Forest Department Government of Mizoram should be made a party in this case to clarify as to whether the petitioner had paid forest royalty to the government of Mizoram amounting to rupees 6,73,000. Which has been recorded in book number 5100, receipt number 001, dated 14/4/2021, issued in the receipt issued by the officer in charge Bhairavi Range / Depot. The reference number of the said receipt is FWO number for subsidy / PMGSY / 57/2019-20 2019-20/4 dated 17/3/2020.
This QR code.
Huh?
Reference QR code.
I know. Mr. A.K.M.R. Chaudhary shall accordingly file an application for amendment for impeachment of the Forest Department, Government of Mizoram. Within 3 days. Within 3 days. This after the bill.
Well, if it- ultimately I file, I will make a mention matter for.
Okay, no problem.
May please your lordship. This is an application. This is an application, my lord, for my impleadment. Originally, there were two petitioners and they were
Just a
representing.
minute. Yes, what is your case?
My case is, my lord, that the petitioners are poor villagers, my lord.
Huh?
Poor villagers living below poverty line.
Yes.
And the electricity connection were disconnected on account of dues, my lord. But there was no practically dues. What had happened, my lord? One Mukti Saikia, the respondent number 4, was appointed as a franchisee, who happens to be a private person, my lord, by the APDCL authority. And the franchisee was given certain rules and regulations within which he was to work. And he was supposed to collect the dues from the villagers. He collected, but it was he who defaulted in paying the dues in time to the APDCL authority. And on our allegation, my lord, on our objection, ultimately he was removed from the responsibility of the franchisee. And his dues were also withheld because ultimately the APDCL authority was supposed to make the payment. Mukti Saikia then.
Okay, yes, what is your case?
What is exactly saying, there was a.
That respondent number 4 did not pay the bills to APDC.
That after perhaps has already been processed. The accounts have been tallied. Whatever dues were there, they have been cleared. As far as the dues of the petitioners here in Komalur, they are towards energy charges or bills or the electricity that they consume. If they have a dispute with regard to that, there is an authority, there is a remedy under the Act itself. It is the Consumer Grievance Redressal Code. The court perhaps will not like to go into whether or not how much energy has been consumed,
Correct.
whether or not that bill is in order. That remedy should be availed by them.
My brother is wrong, my lord. When there is
Show me that.
allegation of theft, my lord, when there is allegation of theft, malpractice, fraud, then the authority concerned of which my brother is talking about is incompetent to look into that, my lord. And second issue, my lord, is that this authority in our area got actually engaged in the year 2023, in the month of May. Our writ petition,
Mr. Counsel, these are all questions of fact.
my lord.
Whether he really defaulted in payment. Did he default in payment? That is
What
point
they
number
say.
4. Oh, that's what they say.
They were defaults, yes, they were defaults, but the amounts of whatever they were, the petitioner, that respondent number 4 had also filed a writ petition before. Claiming certain dues that were payable, the part of the.
Oh, you see, one thing, this respondent number 4, he was the franchisee of APDC. Till which date?
Till 2016.
2016, which date?
31/10/2000.
31/10/2016. So now
And our dues-
the bills that have been paid by this respondent number 4 with regard to the petitioner hearing is till which date?
Prior to October 2016, my lord. Prior to October
Till
20
which date? What notices have you been given? What notices have you been given?
they are not specific, my lord, as to which date, but it is all prior to October 2016, my lord. Till the time Mr. Mukti Saikia, respondent number 4, was in the charge of the franchisee, my lord.
Why aren't you filing a affidavit in this
Once I've
matter?
received the instructions, I can file it.
This is one year ago, this case has been filed.
There's the IA, there's an IA list.
For what?
Implement, my lord.
Of whom?
10 more persons want to join because their electricity has also been disconnected, my lord.
4 persons want to join.
10,
10%.
my lord.
Why
And
don't you file a
all
separate
are-
writ petition?
My
What
lord,
is
they
so
all
difficult?
are- my lord,
Huh?
kindly look at page 19, my lord. Page 19 for a moment of the original writ petition. Their names were already disclosed. Page 19, my lord.
Why don't you file a writ petition? I mean, affidavit.
Yes, right.
Clarify. You see, because for which period have they defaulted? We have got no idea. He's saying that he doesn't know which period he defaulted.
My lord, may I take your attention to page 19 for a moment?
Yes,
19, 19.
I've got it. I've got it.
My lord, kindly see the names of the intending petitioners, my lord. Their names are disclosed there in a table, and your lordship will find that on the right column, what kind of people they are. They are having no fence, my lord. Even they don't have at this age no fan in their house. So they all are poor people, my lord, having no voice. So kindly allow them to be impleted. In the meanwhile, let the APTCL also submit their affidavit, my lord.
We'll allow them. Right. Mr.
SK Singh, my lord.
Heard Mr. N.K. the IA, huh? Heard Mr. S.K. Singh, learned counsel for the applicant, who submits that the applicants may be impleted as respondents number 3 to 13, and to petitioners 3 to 13 in the writ petition, as the grievance of the petition applicants is the same as the writ petition. Mr. D. P. Chowdhury, learned standing counsel APDC, submit that he has got no objection to the application being allowed. So, in view of the above, the application stands allowed. Petitioner to submit what? Amended cost title to the writ petition
My lord.
within
3 days, my lord, we will do.
within 3 days. Then you write in the main case. In view of the order dated 2/4/24 passed in IAC 888 of 2024. So those names are impleted as respondents number 3 to 13. Mr. B. Chowdhury, APTCL granted 2 weeks time to file affidavit in opposition. This is the matter.
Highly obliged.
This one I dispose of.
Well, sir, they have not filed the affidavit.
Otherwise, my lord, issue is regarding cancellation of the, my lord, work order issued to the petitioner in the meeting. There is the arbitration clause. Apart from that, I have got the instruction, my lord, he has already withdrawn the performance guarantee.
Oh, so what remains?
Let them file their affidavit. my
I
lord.
can file it by, my lord. by-
No, but what was the issue here? What do you want?
Issue is non-payment of bills, my lord.
Well, that joint measurement has been made and whatever was due for the incomplete work.
You make an affidavit?
Yes, later I will file.
Okay, Mr. B. Learned Counsel for the
Let him file the.
PWD. PWD is granted.
1 week, my lord.
Is granted a week's time to file affidavit in the police. This is the matter after.
After.
That you also right. He submits that the performance guarantee has been released to the petitioner.
No, he has withdrawn.
Has withdrawn. Has withdrawn.
He has withdrawn.
Has been withdrawn by the petitioner. Both sides.
Some time, Lord.
My lord, my learned friend is taking time after time, my lord, it was very short matter. I'm without possession, my lord.
That is. I will file affidavit, Lord, in this.
Huh?
Kindly see
I
the
file
order
affidavit.
sheet, my lord, how many occasion he has taken time.
Lord,
No.
end of lordship can go to the order, first order, Lord.
The last order, the first order was on 4/3.
Yes, Lord, that order.
And then the second order is that on the prayer of the learned counsels for the parties.
Both parties.
This is the matter on both parties.
It was the request of them, Lordship. My learned senior was not.
No, my lord, here a simple instruction is to be obtained, whether my lord possession of the fishery was given to me or not. And in support of that, some document is to be filed. That's the point, my lord.
That's what I'm confirmed that the possession has been given, meeting, that is none done. We will file affidavit, Lordship, everything will be clear.
He says, according in the last order, he said that some portion of the fishery has been handed over.
No, my, it was not. Actually, we made a wrong statement. We have filed an affidavit clarifying that.
So nothing has been given to you.
No, my lord. My lord, that's why we are saying, my lord, if they would have given us possession, then my lord, why would say all these things? You can't even say, because my lord, my learned friend is appearing in fishery cases from on now sufficiently. But in every case, when a fishery is handed over, and there's a certificate of handing over and taking over, that he has to produce.
That is, he has got, they have signed the agreement. When they signed the agreement, the position has been given, handed over to them. While signing the agreement, we have the records also. I'll file it to affidavit, Lordship.
When?
Give me 10 days time, Lordship. Lordship, we have shortage of staff, Lordship. 217 staff has been terminated, Lordship, illegal employee. Only 16 staff. Lord, we are going to recruit, Lordship. Very short staff, Lordship. Lordship, everybody knows, all I think terminated, lots of camps going on, Lordship. And investigation going on.
Okay, Mr. P. Sharma, learned counsel for the AFDC, is granted 10 days time.
Yeah.
To file affidavit in the police. This is the matter on.
Any day, Lordship.
And after the due vacation, also will fix a date.
Highly up. Highly up.
So just take Mr. Sharma, just one small, he says that nothing has been given.
Yes,
You-
it is not. Okay, that's, I will clarify.
No, whether it is true or not, at least you file an affidavit or
Yes,
just
I
have
will
proper
file an
record.
affidavit.
Give it. Or at least produce some instruction.
I think 27.
But if we were informed by the petitioner that the case will be withdrawn, there's a letter also addressed to the DF.
This is a matter pertaining to 2013.
And that contract term has already
And then the resale notice of 2017. What survived? We'll wait for them for some time. If they don't come, we'll dismiss it. I think they must have heard it now through it. So hopefully then they will come. That time being. Item?
Your lordship, I,
Well,
on behalf of Standing Council, can you produce the last order?
No, you want the writ appeal? What is the last order?
Last order, 50 weeks time is granted to the respondent for filing an activity.
What has happened to the writ appeal?
lordship, that is pending.
Pending. That writ appeal has put this order to challenge, isn't it? Huh? Is it?
Order has
Order has been put to challenge. And so status quo has been directed to be maintained. What has happened to the?
It is still at the stay, madam.
Okay, so we'll adjourn the matter. Nothing can be done now, madam. Status quo has to be maintained, but status quo to be maintained means what?
That part also, madam, I need some time to prepare this defense because there was already an apology affidavit in the writ proceeding.
Okay, Mr. D. Gogoi, then counsel for the respondent is granted 2 weeks time to file affidavit. This is the matter after 2 weeks. Full stop. They also submit that the writ appeal is still pending before the division. Item.
What is matter?
He was supposed to give me judgment. He's there.
Around the last revision. Because we wanted to know that what is the percentage of the line is the raw material.
Okay.
I required from the petitioner, it is nearly 25%
Fly ash is 25% of the cement,
of the raw material.
of the raw material. Of the raw materials for manufacture of cement.
Secondly, you also wanted to know
Yes.
that fly is where from the available, is available only in the power plant. And it is mainly coming from the state of Bihar in the northeastern region, the fly ash is not available. I think you also wanted to know, look into the 97 investor policy. Transport subsidy at B, phase one.
Huh?
At B, at phase one.
So out here say the transport subsidy scheme will be extended further.
Right.
Insofar as any states are concerned for a period of another 7 years.
Right.
Up to 31st March 2007.
Right.
We core terminals to the 10th year of 2015. Now, the 2007,
Look at
there is no, there, huh?
the dossier looks into it. It is 97, the notification is there. And if it is mentioned to the 7 years, up to 31st March 2007,
Ah,
the page that you some mistake is there to be 10 years.
no, it's, ah. No, anyway, so,
31st March 2000,
uh,
10 years. Because it also says four terminals. In this
no, then subsequent to this notification,
Right.
is the office memorandum dated 2007?
by the
Where is that?
2007 policy sheet, you'll also find at page 42. And the relevant part at page 45.
42.
Clause 14.
Clause
14 at page 45.
But it doesn't give the last date out here.
Last date is not given because you'll also find the last part, in view of introducing necessary safeguards for instance, for the policy is for 10 years, the promise is for 10 years. So it actually presumed for 10 years. Subject to, of course, the review or safeguarding leakage or the mission.
Where is this? It was an evaluation had been done.
Right.
Evaluation had been done. Where is that evaluation?
Evaluation has been done by them according to the new trade policy has come. But as I said before, the judgment of the effects for the public power for taking case, where the single methodology was there kept an issue. And the effects court state that unless until the materials are presented to the court, there was issues and the theft of the partner thing on the basis of simple statement will not do. And here they have not stated anything that there was an misuse or theft of in the affidavit. They have not stated that this is the ground. They simply say that this is a change of policy.
There must have been an evaluation done. Where is that evaluation?
Evaluation is not next, but I have made a statement in my affidavit. Paragraph 4 and paragraph 7.
No, you see, because your change of policy would have been made on the basis of that evaluation. So let us see that evaluation.
And evaluation must be for the regions which have been mentioned in those 40.
I don't know. We'll see.
It has to be on that basis only, because that the weakest and machine. Now you can also remember, once again, we don't do station. The UP Power Corporation case, which I placed for 2008 to
You did not give me any UP Power Corporation.
UP Power Corporation below have 2008 to
You did not give me any. I think today was the day where you were supposed to give all the judgments.
Judgment, in fact, I thought that once, I think it within 1 day, I will somebody. There's been a place of judgment again. And I went. No, it was, we have, so far, we are supposed to have it. But it was just pass over my copy. We have to give it certain, scientific.
No, I don't remember. You'll have to just a minute. Just as Mr. Kalita has given 2023 1 SEC 386.
That is Hero Honda. That Hero Motorco.
And then 2019 10 SEC 575.
That's not the government policy.
Then Mr. Dr. Sharaf has given only one.
No, but I,
1997 7 SEC 251.
that I was the Motilal Padampat was the first case I faced for lot.
You see, because I remember today is the day you were supposed to give me your list.
But I was supposed to keep the 7 part of the.
Yes, all today, because that time we didn't have time to complete.
There is no report. I thought, 1 day, tomorrow itself I'll keep.
Okay. Tomorrow is Wednesday, and day after tomorrow full bench.
So your lordship may just only the judgment citation only have to give and the.
Correct, you have to give. Yes.
Your lordship may, the hearing may be over, your lordship may just one judgment I may play. Your lordship last occasion also.
Okay.
The question was that, Milord, whether the industrial policy. Agreement, Milord, this is the state of Jharkhand versus Brahmaputra Middle East.
Yes.
Your lordship. Para 22 euros.
22. Yes,
No, the people.
yes.
655. The LRTC expected of the industrial policy council, the state of Jharkhand did not find the influence in the administrative efforts. The High Court has specifically referred to the case of the Bureaucrat Lesanti as a matter of first principle. There can be no gainsaying fact that when a state such as Bihar Act bound the state to grant exemption from the provision, the state has a discretion to determine the date from which the fee for this exemption is operated. An industrial or entity cannot compel the state government to issue notification for that exemption or to issue for the terms of the government. So whether an exemption should be issued or not, terms of the exemption have to be determined by the state. But this does not rest on the principle, nor did the claim of the respondent require the High Court to make a departure from the industrial policy council contained a representation that a rebate or election could be granted. It held a representation that a notification will be issued in a month. These are following communication made by the state happened, which remained was that implementation by issuing notification, which was to be done within 1 month. There was plenty over and we come to level page 25. In this chapter, the High Court, which execution is perfect with the decision of the Supreme and industrial policy has been justified in science of Bihar. The policy contained a provision for monitoring and reviewing the industries. All departments organizations could have a follow-up calculation to give effect to the policy within 1 month. It was similar to close point for the policy in the present case. No notification was issued that Bihar to give effect to the policy. The claim of research that mentioned by the unit was rejected by the state government on the ground that it has decided not to grant the incentive to execute the period. A follow-up notification was issued so and so. Thereafter, I got to make an issue of para 28. Where the communist of the doctrine was enlightened. 27 was. In order to analyze the contents of the electing doctrine communist purpose in the present case, it is necessary to discuss the origin of the doctrine and evolution of its application. The common law recognizes various kinds of suitable couple, one of which is communist couple in showing so. Thereafter, all the decisions below they were discussed and you lost me when I speak. Para 33. This court has given an expansive interpretation of the doctrine of communist purpose in order to remedy the injustice being done to a party who had relied on the promise. In Motilal Padam, this court used communist purpose as a principle of equity, which was not hampered by the doctrine of the conciliation, as it was placed under the English law. This court is speaking for PM Bhagwati Ji. Thereafter, what PM Bhagwati Ji has mentioned. Para 39. While this doctrinal confusion has been confronted the consequence of the making the law unclear, citizens have been the victims. Representative by the public office needs to be held in trust standards. Since citizens continue to have their lives based on their trust and repose in the state, in the commercial world also, certainty and consistency are essential in planning the affairs of business. When public authorities fail to adhere to their own determination without providing an adequate reason to explain for this failure, it violates the trust repose of the state. The generation of the business friendly climate for investment and trade is conditioned by the faith which can be imposed by the government to fulfill its position. Thereafter, I got and come to the road. Paragraph 49.
49.
I look. Or 48. I mean. Applying the aforesaid principles in the present case, we are able to perceive any substance in the submission of the state which us in defense before the High Court. Not only did the state in the present case hold out the following presentation. This presentation was founded on the stated desire to encourage industrialization in the state. The policy that followed. The state having held out the following representation in the above terms, it would be manifestly unfair and arbitrary to deprive industry needs within the state of the legislative expectation. The state government did, as a matter of fact, issue a strict notification in the section 22, whose prospectively within the effect of 22. The document over para 59, the last 4 lines below. The state must discard the colonial of the notion that it is the sovereign handling out those who it will. The policy give rise to legitimate expectations that the state will act according to what it puts forth in the public will.
in all the sections, the state is bound to act fairly in a transparent manner. This is an elementary requirement of the guarantee against arbitrary state action under Article 14 of the Constitution of India. A deprivation of the entitlement of the private citizens and the private businessmen must be proportional to the requirements grounded in the public interest. This conception of power has been recognized by the court in the consistent line of decision. The relaxation is to be like grant to occupation national building to include. The government and department in administering the affairs of the country are expected to order their statement of policy or intents that achieve the citizens with full personal consideration without any iota of any discretion. The policy statement cannot be regarded unfairly or applied selectively. Unfairness is a form of unreasonableness relating to the burden of the citizen. Therefore, it is clear that the state has made implementation to the respondents and similarly stated testimony under the industrial policy of the control. This implementation gave rise to legitimate expectations on their behalf that they will be offered 50% fund leverage reduction in electricity for the next 5 years. However, due to failure to issue notification within the stipulated time by the grant of the exemption only prospectively, the expectation trust in the state could be achieved. Since the state has offered no justification for delay in exchange of the pension, thereafter was to the similar. There are 65. In this new matter, we are not inclined to interfere with judgment of the High Court on the grounds of delay alone when the judgment is based on legally sustainable principles. The delay in the respondent filing the petition by itself should not defeat their claim unless the position of the state has been altered that it cannot reflect on the ground of the lapse of time or the intention of the parties. The state has not in the present case either treated or argued any hardship if the respondents were granted relief. Finally, the decision in so and so related to the petitioner seeking refund of illegally collected tax. In the present case, we are not concerned with such a situation that the petitioner has come up before the court due to arbitrariness with the state action, which led to the non-fulfillment of the expected. So, my lord, this court and ultimately, my lord, the conclusion, you will find it. The court said, my lord, that even if the state notification has not been issued, then also on the basis of the industrial policy, the petitioners will be entitled to the rebate which was promised in the industrial policy itself. In this case, the state has not issued the notification for granting the rebate.
That was a different context. They had not issued the notification because so they could not be.
It is further important that the notification was not issued even when the court said that on the basis of policy itself will be entitled to. Not to speak of the notification. There the policy was there. Now the judgment which might understand below case for the hero Honda. There the GST Act was enacted. That was the legislative change, the earlier act was repealed. Once and you also know that there cannot be any promise paper against the state, against the legislative action. But the earlier act was repealed and the GST Act came into force. The court was examining situation after the GST Act came into force. So that judgment has no relevance in the present case because in that case the court said with the change of the policy enactment of the GST Act, the earlier act had been repealed. They were subsumed in the GST Act. So there was change in the policy, legislative policy. Once there is a change in the legislative policy, then the things are different. Here the implementation which was made that you will grant get the transport subsidy, but subject to review on the ground to prevent misuse or the theft or whatever it is. Now in UP Power Corporation case, the Act of Court clearly held that once you say that there is the misuse and theft, then you must bring the materials before the court to show that how there was the misuse in theft, 35 of the UP Power Corporation case, that how there was the theft and of the electricity, that has to be presented, 35 million.
No, I don't have all that.
Lordship may do one thing, sorry for that. I will, in 2 days or 3 days, whatever is lordship presents, I will prepare a detailed note and submit it along with it. Because my issue is a lot on this basis only. Support of that, whatever judgments are.
No, the reason we fixed today also was for your judgment.
I really will.
Anyway, you see, I don't think we can do it now before the vacation. Because tomorrow is motion day. And thereafter, we've got a full bench at 2.
Thereafter, the regularly motion will come.
Then, so Friday also, everyone is asking for last minute
Next week.
this thing. Very difficult. Now, one thing I just want to clarify. You had said, Mr. Kalita, one thing.
Sure.
Regarding you had spoken about the registration of the petitioner. And with regard to some date, 31/3/2012.
Yes, sir.
What is that?
A lot.
There's some letter dated 31/3/2012. What is that? Just want to clarify that.
The Lordship, I basically submitted on one thing is that, first thing is that
There was something proposed some building when I going to start construction or something like that.
yes, sir, they are right.
Date of commencement of commercial production
Yes,
origin.
yes, sir.
Okay. I think it is page 64.
64. Yes, Lordship, page 64.
What do you want to show out here?
So Lordship, what I was saying that their registration, first thing is that their registration has been given by the general manager TICC. So this registration was given under a transport subsidy scheme. If you need to, if you are supposed to claim transport subsidy, then you have to pre-register your
Uh-huh.
unit.
Uh-huh.
So pre-registration, when the pre-registration was done, it was done
Just
on,
a minute, just a minute. Just a minute. To claim subsidy.
yes, for claiming transport subsidy, they'll have to pre-register themselves under the transport subsidy scheme.
Yes,
Now they have registered on 31st,
2012.
correct, Lord. And their Lordship, they have not given any date of commercial production. Serial number 1, that they have stated as proposed, because they were not sure, obviously. So they have given proposed. Now this scheme has come on 22/1/2013. Correct, Lordship? Now
31,
22/1/2013, the scheme.
the
has
new scheme. Huh.
Correct. And they have missed this date. I mean, this transport subsidy date by 8 days. That Lordship.
9 days. 9
Yeah, 9 days or 8 days. So now what I was submitting here, Lordship, whatever promises has been made, if at all, the promises have been made under that scheme. Under the transport subsidy scheme.
Correct,
Not
correct.
under the transport subsidy scheme, and that has already expired.
Correct.
So because you have registered on a transport subsidy scheme, and whatever the promises has been made by the government, that has already been expired. Now they have come under this freight subsidy scheme, wherein the government talk about with their wisdom, they have come up with a different policy, saying that price is will be in the negative place. So there is no promise, Lordship. So whatever promises they, I mean, if they want to show that there was some promises made, then they have to show that under this 2013 scheme, there was some promises have been made. But otherwise, that thing is already over. That transport subsidy scheme is already over. And government has not, it's, I'll just show Lordship. From the affidavit, what Union of India has stated. Just a second, Lord. So Lordship, my learned senior has been arguing that like change of policy can be done only in case of misuse.
But as per the policy on
No, he's not saying that.
that evaluation can be
He's
done.
saying because of the clause 14 in the NEIPP, that whim.
Correct.
Out there, clause 14 says that there will be a
Evaluation.
revaluation
Correct.
of the scheme, the transport subsidy scheme, with respect to the leakages and misses.
Correct also. But in the same scheme, Lordship, if your Lordship turns to page 46 now, page 46 of the requisition.
Yes,
46 of the requisition, Lordship.
government reserves the right to modify.
Yes, government reserves the right to modify any part of the policy in public. Any part of the policy. There is no qualification there. So this right is already there in the government. And like what Indian government has said in their affidavit here, Lordship may kindly pick up that affidavit, Lordship, that page 130 here.
Page 130.
131, page 0. So they have given some reasons why they have changed this policy.
Yes.
Page 130, paragraph 11 here also. I'll just read out here. That with regard to the statements made in 13 and 14 of the requisition, the deponent begs to state that it was earlier proposed that the total amount of transportation cost eligible for transport subsidy for any raw material finished product shall be subject to a maximum of 50% of the value of the particular value of that particular raw material finished product, which was not agreed to by the beneficiary states. So it was proposed to disallow subsidy on transportation of fly ash from outside NER as this material is of low value but high in volume. Transportation of such huge bulky material from outside NER over long distances needs to be discouraged in order to promote more efficient business models necessary for self-sustenance of the industrial units. So this is the reason they have given why. Because northeastern states, they themselves said that like it is not feasible, it is not required. So there must have been some.
No, but is fly ash a requirement of for making cement?
The fly ash is required.
So
The fly ash
so-
is required, but it's a certain percentage of the
he's saying 25% of the
28% or whatever that raw material. But like reason has been given that like this has to be discouraged because this has been the policy has been.
so can cement be made without fly ash?
I mean that much of the 25% maybe they can from their own cost they can do it. So policy has to be government will give subsidy not on everything, on certain things. So certain things they have discussed because while the policy was framed, then obviously there was a discussion between the concerned states also, and states discouraged it, and that was the reason. Then
Can we see this evaluation? I think, yes, I think you better because I think he needs the date for giving you the thing. Dr. Sharaf, I think you have to give a date.
I think I will put the definitely on that state. Also the meeting that there must have been a meeting with the state and the state has discouraged the ground to
Uh-huh.
that the state Byron, just a minute, please. When you are arguing on behalf of the state, every sentence on behalf of the state matters. Promise was made by the union. On the basis of the union's promise, the state is coming forward. And the state is saying that the discussion must be there and the state has discouraged for the grant of subsidy. Let him file an affidavit to the score that the state has also discouraged the grant of the transport subsidy. Your lordship will read the paragraph. The paragraph in the affidavit. Please, kindly let me also give a video statement. Paragraph 35, when it was made to be limited to 50%, the beneficiary state objected that it cannot be restricted to 50%, and it should be full exemption. Now, on the other hand, now the state is saying, you'll also see paragraph which you were reading in the affidavit.
Para 11.
No, I am just stating, Lordship, I am just stating whatever has been stated. I mean, No, my lord,
Written in the affidavit by
my
the
lord,
Union government.
affidavit on behalf of the
I'm
Union
just
of India.
pointing, I'm just
He is
pointing out.
appearing on behalf of the state.
I am not arguing
My lord,
on behalf of the Union.
no, no, you are arguing on behalf of the state, I fully understand. But while arguing on behalf of the state, you must take a stand, and whatever you are submitting before the court, you must place it by way of the affidavit. Without placing an affidavit, you cannot make a submission that the state has also discouraged the grant of custody. If this is so, let the state come up and say that we also are consulted and we also discouraged the grant of subsidy on the flyers. Let it be, my lord, on the record.
Lordship,
Without that, my lord, the oral submissions on behalf of the state cannot be accepted.
the Lordship, if the evaluation is brought in, that will show.
No, no, but
If-
his submissions,
I am submitting on the basis of whatever is written in the affidavit.
or whatever is not your affidavit. This
No,
is the affidavit
I am
of
just
Union.
pointing, I stated there is a Union government's
It
affidavit.
it cannot be, state cannot argue
I am
on the basis of the Union government's affidavit and say the state must have also. Because I have never heard, my lord, when the state is coming forward and after the submissions are made of the state, it must be put on record. Let it be placed on record.
No, actually what has happened is now the petitioner expects the state government to support the petition.
My lord,
However, he is supporting the union.
let him support. But if that is the stand of the state,
So that is why. So basically he's saying that you are making submissions. You cannot make submissions without pleading.
my lord.
I am just
So,
pointing out what.
I know you're pointing out, but then it's hurting him, his interest. That's what he feels. So
Okay, my lord,
Yeah,
whatever he's pointing out, my lord, the Mr. Chaudhary is also.
Mr.
Very
Chaudhary
good.
can point out.
Lord Chaudhary has already pointed out, but the same coming from the mouth of the state, it must be there in the record that yes, the state is also saying that no, transport subsidy on the flyers should not have been there. Let it come.
Okay, so what we'll do is, Mr. Chaudhary, you please bring the evaluation. You please bring the evaluation so that we can have because you see now there are two aspects basically regarding I don't know how to interpret.
And one more thing, my lord. My learned friend said, my lord, that the promise was made under transport subsidy scheme. No, I've never argued that the promise was made under transport subsidy scheme. My entire argument is that the promise was made by the industrial policy. The policy has not been amended. The last part which is saying that the policy has the right to withdraw or amend the policy. Where is the amendment of the policy? There is no amendment of the policy. The Northeastern policy has not been amended as yet. And as you also be aware that whenever we say that he has the discretion in the tender matters, to discretion to accept or not to accept, that discretion is not available. Any withdrawal, any amendment of the policy is also subject to the doctrine of the promissory estoppel. You cannot.
When did you start your construction of your
Very
cement
long back.
factory?
Long
When,
back.
when was that?
First registration, my lord. '64. 2009, my lord, the Pollution Control Board consent to establish was given,
Where is that page?
page 54. The factory was entire complete,
Page 54,
my lord,
consent to establish.
my lord. Then, my lord, page 47. The certificate of registration of the policy was granted in 2009.
Lordship, ultimately the key thing is the key aspect is a commercial product. Whenever you start, that is immaterial, Lord.
Anything, my lord, cannot start within one day. The factory cannot start in one day.
But factory started, I mean.
No, you cannot,
can-
if
can
you
you
want to
expect-
speak against the petitioner, please come up by way of an affidavit, we will reply. Otherwise, he has no opportunity to argue in support of the Union of India. I am surprised. The state should have come up in favor of the industry, and the state is coming up against the industry. Really surprising. I think whether he has got the instructions or only on the basis. Let him have the instructions whether he to speak against the industry and come up with an affidavit. It will be better if he can come up, my lord, with the instructions that to file affidavit and to oppose it. Without that, I think your lordship will not consider a single submission made on behalf of the state.
Yes. So, yeah, you're not filing any affidavit.
It's a federal government policy. I'm just pointing out what is there on record.
No,
I'm not,
I will file affidavit.
I'm not submitting
I will
anything
file
out.
affidavit
I am not
opposing
submitting
the
anything.
stand of the state and saying that without an affidavit, I will place the judgments also without an affidavit, taking contrary stands. The state is not entitled
I'm
to
not
make
taking
any submissions
I'm not taking any.
before the court. And if he is speaking all these things, then I will place on the court that these are without instructions and without any taking from the state.
No, I am arguing on the inspector something and.
Yes, you place it.
And these are on record.
Place it
I'm
on
not
record.
submitting,
You
no,
place
I'm
it.
not submitting anything.
We have not made a single allegation in the petition against the state government. This is against the union government. And if the state had decided to commit, and my learned friend said that he has instructions, let him file a one-page affidavit. Let him file one-page affidavit.
Anyway,
Without any air, he will cannot argue, my lord, that simply,
anyway, he's not filing any affidavit. He says.
then I will file affidavit opposing it, submission,
Ah,
that without instructions he is arguing, I will file it, so that he has to reply.
Lordship, let me clear my step. Whatever is there on the record, that's what I'm putting.
My lord, I am going to file an affidavit that the state has argued these things. And pointing out that if the state stand is there, then these are not the stand of the state. And if he wants to oppose it, he has to file a reply. I will file.
no. If you are going to file it, then I will release it from Parker and I'll give you time.
Well, what can be done? He is arguing something which is not on record, nothing. And he says that I am arguing on behalf of the Union of India. Without what I can do, either he must file an affidavit that he is arguing on behalf of the instructions of the state.
So then you file your affidavit. What to do? Otherwise,
Whether the affidavit is for what purpose? That only
no, I'm not. I'm just asking because you said you'll file.
whether-
So I'm not on that.
I'm only because he is saying that I will argue also, I will not file affidavit also. That is only the reason that to compel him to file affidavit, I will file it. He reply. No, not pointing out is nothing. You are arguing against me. You are not pointing out.
Pointing out what is there.
R.K. Dev Chaudhary is competent enough to argue his case. Somebody else will come tomorrow and start arguing.
Huh?
I will take this.
Uh-huh.
They are not this music chair. They are going here and there again and again. Nobody knows whose business is this. No, I am not a person flying. No, it's not the legal issue is there, the legal issue, whatever is
No, I understand.
arising. And
Huh?
whether Mr. Kalita says, whether Mr. Chaudhary says, it will not make a difference. It is only become I become a little on the basis that industries are coming in the state. And the state is objecting when the state is giving 200% GST refund to the industries.
Lot of money at stake.
So they should come forward and support.
So lot of money at stake.
There is no doubt about it.
So the amount of effort put in is directly proportional
Yes. But the amount of export is not dependent
To
on
the-
at least.
to the instructions received. Anyway,
But I can do, Milord, on the your last thing, it fixed after vacation. And prior to that, Milord, in advance, Milord, before vacation, I file my written submission along with the judgment, so that file it before that, Milord, so that you can also get some.
no, you see, that was the basic reason I put it now,
Yeah, that's it, Milord.
so that I could do something.
Look.
But now, since you all are not ready, I don't want to do things half big. Because now the evaluation is going to come out.
The evaluation is fine.
I want to see the evaluation.
Okay.
Yes, you see, one thing I just wanted to know.
Yes.
Hmm. You had said that total amount of transportation cost eligible for transport subsidy for any raw material was subject to a maximum of 50% of the value,
Proposal. That was proposal,
which was not agreed to by the beneficiary state. What is this? I don't understand.
But earlier, the transport secretary was said only 50% will be given, but beyond
Okay.
that, the state has not agreed. State said no, full,
Okay, so the full will be,
full should be given. The state was in my favor. Today, state is speaking against me. Whatever 5 years cement, whatever is it.
okay, another thing, where you had relied upon some judgment of the division bench of this court.
That was
That
shift.
yes,
That was 2007 one GLJ 259,
yes,
wherein
yes,
in the concluding paragraph,
yes,
this honorable court has held.
yes,
This was of course a matter under the income tax,
correct.
where the court has held. We are of the considered opinion that the transport subsidy received by the accessee during the assessment here,
Where is it?
in my lordship, it is
Para
paragraph 25.
25, yes,
It's just the second last paragraph of the judgment.
yes, yes,
2001-2002 is intended to stimulate industrial activity in the backward region to generate employment opportunity and to bring about development in the any states, and it is not meant to provide higher profit for the enterprise.
correct.
Now, what is happening here? Lordship will appreciate why we have changed the transport policy, Lordship. That we have laid out in our affidavit in paragraph 14, where we say the deponent makes the reiterate that a conscious decision was taken to disallow subsidy of transportation of fly ash from outside NER, as this material is of low value, but of high volume, and that the transportation of such bulky materials over long distances need to be discouraged in order to promote more efficient business. In order to promote more efficient business. Now, now we are in a stage, Lordship has come across. Now, something has been developed that we can use as a subsidy for sand in constructing our house. If your Lordship has come across. Very recently, something has been developed by the IIT that we won't need sand anymore
Okay.
to construct our house. There will be some substitute. Those are new activities coming up. Should we again go on with the old things?
So, but till that new things come up, what are you going to do?
Now, Lordship, here this fly ash, as it is a very low value, Lordship. It is very low value. And transportation, Lordship, how Lordship a full rake of fly ash. It would be much more than the cement itself, if I may say, for the transport.
Maybe. You see, that is why this Udan 2, Udan 2, Udan 1, all these air connectivity issues were also taken up. I mean, there's so many ways to look at things.
Lordship,
It's not only cement.
Lordship, there might be
So
something else,
many.
deliberation.
issues. Yeah.
Let me get that deliberation now.
Because you
How
see,
it
one
has
thing
come
is that one issue is, you see, cement. If fly ash is a major component, if cement cannot be made without fly ash, maybe a low value, but the essential component of cement. So, I'm keeping in view the fact that if it's outside of any region, then that cement factory can never come up here. because the cost of transportation of the cement component is going to be so high that they cannot be able to, they won't be able to compete with the cement manufacturers from outside the region. So I'm just looking at it that way. I'm not looking at
Cannot
it.
be so logic because
That's why,
Lordship knows limestone is also major raw material for
no,
manufacturing.
no, so that's,
In all cases,
so if you can find out whether making of cement, whether this fly ash is a mandatory essential component, or can it be made without fly ash? That can have a I just want to know. I do not know whether it'll have a bearing on the issue.
educating myself also.
Yes.
All right. One more thing, Malad, let me take right up. IAS is available in the notice, please. That is like because just now I'm saying it's not available. No, I'm saying it, but only by saying after releasing Union of India, by saying will not do. He wants me to substantiate his. No. Malad, the thing is that, but the IAS is low value, very good. Transportation cost is very heavy. Very. If it is not available in notice, please, then the cement industry will not have established the industrial unit here because they will have to bring the steel from outside. There is a high transportation cost. Now, the question is that if the 5 years only for the purpose of transportation, they are bringing the 5 years instead of some other things are available. There's some other alternative thing is there without use of the 5 years and only to earn money, the transportation cost. Because what they are giving of the transportation which is cost which is there, out of that, the percentage of that. The transportation cost must be incurred for bringing the goods to the state. So they are not giving it. And lastly, in one of the judgments, next time when I give it, the question of unjust enrichment was also dealt with. That whether the benefit which is declared is unjust enrichment, input says nothing to it. The excise exemption is given, Milord. The excise exemption, what is exemption, Milord? You collect from the customers. You collect from the customers and keep it. Will also fix another date, Milord, so that on that date prior to that, I will give everything. Right. I'm sorry for that. So far as Lordship, my part is concerned, Lordship would want the deliberations of this evaluation. Yeah, evaluation.
I want the evaluation and any other judgment, because that judgment that you had brought in, that was basically with regard to whether it was a capital gain or
Receipt or revenue.
a revenue receipt. So that was slightly a different context.
In fact, the Supreme Court subsequently held if the transport subsidy is a revenue receipt.
But revenue receipt is taxable.
Your revenue receipt is not taxable because the new industries are exempted from the income tax. So
No, it held, I think that it is a capital. What was the word?
Not the
Capital inflow. What is it?
place before asking the judgment of the Supreme Court in Meghalaya state, 5 years back has come, where they said because the industries which were exempted from the payment of income tax.
Yes.
And the payment of income tax, they were exempted, and the income tax authority treated it to be the income from other sources.
Ah.
The Supreme Court said that no, this is income arising from the profit and gains of the business. Capital receipt issue was not
No, but a revenue receipt is taxable.
taxable.
Revenue receipt is taxable.
Taxable. But below what happens, the new industries, it is given transport subsidy given only to the new industry units or expansion units. They are equally exempted from 10 years from the income tax. So, without if it is not treated to be business income, then it is treated revenue income, then it will become taxable. The Supreme Court said that no, this is a profit arising out of the business of the person concerned. So that it becomes exempted, even if treated to be business income, it will be exempted.
Even if it is that means it's not a revenue receipt.
It is revenue,
It's a revenue receipt, but not taxable.
not taxable because it is income arising from the business of the industry. And
Or is it, or was it because it is said to be a capital inflow?
earlier there was a dispute whether it is a capital or revenue.
Okay, but now it says,
Now, it's
okay,
written that it is a without
revenue receipt, but,
Yes,
okay.
yes. Because transport subsidy is only given to the new industry or the industry undertaking expansion, and they are exempted from income tax. So the Supreme Court said that it is the income arising out of the profit of the business. Profit means revenue, but it will be exempted. Transport subsidy is not given to other industries. I place people also, that is Meghalaya state. This Honorable Court held that yes, it will be exempted, income exempted,
Because it was a capital inflow,
Not-
not because it was a revenue receipt.
not because the capital, capital is, they have not said. They said it is a revenue, but income arising from the profit and gains of business.
Anyway, I'm slightly new to this.
No, just I will for the information of law.
Yes, yes, yes.
I will give the judgment. Where the
No,
judge
no.
said
Yes.
that it is an income arising from the profit and gains of the business.
Okay.
And profit and gains of the business means revenue receipt. But since it is exempted in income tax act, so it also gets exempted. Otherwise, not the entire income tax has to be paid revenue receipt. And the capital receipt is not there.
What is the difference between capital receipt and revenue
The capital
receipt?
receipt is only for the purpose of something going up, something like when the capital subsidy is there or investment in the capital project.
For say, for construction of a building, supposing they give 30% of the cost, that will be capital.
And that is mainly before the setting up of the industrial unit. And this is the
Huh.
regular for 7 years.
And this is since this is paid after the
Right.
establishment, so it becomes a
And not for
revenue
the
receipt.
establishment of an industry, but for carrying out of
It
the.
is an incentive. Anyway, okay, right.
So you just give it, next regulation will be over before that will start.
Huh?
The next date it will be perhaps it will be over.
You just give me those judgments. Actually, I was not waiting for anything. I was just waiting for your judgments. That's all.
Plus, because he will also highlight it here.
Yes. Now, but since after all this little bit of hearing, a little bit more, I want the
I will
reevaluation.
give my written, so it is mission and we will the judgment.
Make it small,
Very small.
thin. Make it thin now. Okay, right. I heard Dr. A. Saraf, learned Senior Counsel for the petitioner. Mr. R.K.D. Chaudhary for the Deputy SGI for the Union of India. And Mr. A. Kalita, Additional AG for the state government. Standing Counsel for the Industries and Commerce Department. The party shall provide the citations in support of their submission, while Mr. R.K.D. Chaudhary shall provide the re-evaluation done on the Transport Subsidy Scheme 1971 in terms of clause 14 of the NEIPP 2007 on the next date. When? This is the matter after the.
I'm going to be in spite of.
Huh?
In spite of making him the submission. But if you cannot do it,
I
I was looking up the judgment yesterday, therefore yesterday Litchfield Miller, the High Court judgment. The promotion and the Secretary of Chief Justice, the power of the Chief Justice. I was going through it. So I don't think that the your lordship, even if it desired, could not have made it 5 pages because it has to be without the entire judgment. An interesting reading without that judgment.
Let it be clarified by the apex.
That is correct, but your lordship in the last 3 paragraphs has an interesting reading.
Okay.
The power of the chief is subject to my how special.
I don't know.
If it can be after 3 times of this much. This much supply for no, at least.
That's it. Mister? He does the paper point number 4, huh?
I'm highly obliged.
This goes separately. This is done separately. This.
Yes, I was supposed to produce the tender related documents.
Huh?
tender related documents of 2018 Lordship. So, Lordship, we could not trace it out, Lordship. I need some more time. During that time, there was a scam related regime, Lordship. So I don't know whether it will get it now. We have filed an FIR regarding it. Filed,
Item two.
Lordship.
Submission is believable, then there is
Record-
itself is a scam.
Maybe, Lordship, we'll go accordingly if it is if I do not find the record, Lordship.
The settlement holder, tender of settlement holder is defected in 4 counts.
It is only, 11 months to go to complete the tender, to see his figure, this person's figure.
So?
So, no, Lordship, my submission is that give me some more time to trace out the record. We could not trace it out.
Mr. Council, this is a 2018 matter.
Lordship, yes, Lordship, but the fact is that this managing director text took charge in 2021, Lordship. After that, only we are recollecting the documents. We have lots of development have taken place in the corporation. So give me at least another one every time, Lordship. Every class comes, Lordship. If nothing had happened, we'll give it in writing, Lordship. Otherwise, I don't want to, using written instruction, Lordship, when we get it, Lordship, what it happened, Lordship.
Tax payment time is running. Only 1 year.
1 year is there, Lordship. Yes, sir, not listed also, Lordship.
Even to my knowledge, my lord, after getting this settlement, perhaps petitioner also lost interest and as informed by the
As per the record was after going to the one part of the record, it is found that they are supposed to pay around 30 lakhs, around 29 lakhs to pay. So we may cancel it also. Lord. We are on the process also. That part is petition.
You have not done anything.
Had not done earlier. We could not produce the record.
The problem is also you see, it was listed prior to listing in 2024. It was last listed in 2019.
lordship, because of not filing their affidavit and independent COVID also there, my lord. Since we filed challenging the settlement, my lord, even lordship considered that find that the settlement was legal. There's a 1 year left. That could be adjusted to me, my lord.
Respondent number, who is the private respondent?
In case if you will find a previous order, my lord, in the last several occasions, it didn't appear.
But he has filed an affidavit. I will pass the record of it. This bank is there.
You are supposed to produce the record.
Lordship. Yes, sir. That is the reason I'm taking time, Lord, to trace out. Let it be fixed on any date, Lord. 10 days, I think. 1 week or 10 days.
Huh?
7 days or 10 days, last month.
Last chance.
Lordship.
What to do? Mr. P. Sharma, the counsel for the AFDC, is praised for giving him last chance to produce the record.
As it was to trace out the record.
To trace out and produce the record. Good stuff. On perusing the orders passed earlier from I-16 that 3 chances have already been given to Mr. P. Sharma to produce the record. However, the same has not been produced till date. It is made clear that in the event Mr. P. Sharma is unable to produce the record on the next day, the matter may be disposed of on the basis of material on report. Place the matter on 9th. You said 1 week.
Last day. It is motion day. It is motion day nowadays. Lord.
Maybe,
It is motion day. It is
Okay, when?
after Bihu, Lord, 23, then 23, 24.
21.
21 is a Sunday.
9th is not motion day.
Oh, 19 is a night.
Tuesday.
9.
Oh, there is declared motion day. Okay. What? Oh, Friday. From Thursday, all motion day.
Okay, immediately after evacuation, my lord.
When?
Or
20, let it be.
18
We
or
may be
19.
outside. Lord. In 19 is the election day, Lord. It's the holiday declared.
lordship, what's the
problem.
18, 18.
Yes.
This is a matter of
Yes.
18.
Lordship.
Mr. D was called me a paper for number 7.
22. No,
Ah, this is a matter of 18.
22, 22.
18, 18.
Not it, I
18.
think
Huh?
holiday Lordship. 17 is a holiday.
So, 18 is a working day.
Only one working day Lordship.
So,
You will get it to 22 Lordship. Outside Lordship.
you have to go outside. Where?
Somebody with children to have to go somewhere.
You are not going to vote.
It may not be Lord. Only one day.
No, no,
19 is a holiday Lordship.
What holiday is it, 19?
19 is a election day. Declared election.
Lordship election is held in Digrugarh, Lakhimpur and that's what.
Ah, there is no holiday here. There is no holiday here.
Okay, then. Okay. If it would have been 22, it would have been better. Lordship.
You want to go on a holiday with your children?
Yes.
Are you sure? But supposing we see you here, then what happens?
No, Lordship. Actually, there is a problem to still. I will be coming on 18, Lordship.
Okay, 22.
About
23.
23 minutes.
Twenty-
Like 27.
20? Is
Better infrastructure. So there is 2 years settlement.
Ah, which one? 27.
Supplemental. Supplemental, that's only.
That retail notice of
Then
2017.
Commissioner has written to the DFO that he doesn't want to.
Who got a petition? Only my submission is my note that the earnest money be released within a period of 1 month.
That will look into. That.
I will produce the certified copy of the order. My note they will.
Mr. J. Sharma, learned counsel for the petitioner, and Mr. D. Gogoi, learned counsel for the forest department, submit that the petitioner has submitted a letter dated 30/01/24 to the DFO Dibrugarh Assam, saying that he may be allowed to withdraw the writ petition. In view of the submission made by the council for the parties, the writ petition is dismissed as withdrawn. Full stop. The-
Earnest money deposited.
the prayer of the petition council for withdrawal of the earnest money fully considered by the forest department will be considered at the earliest when a decision and the decision communicated to the petitioner.
Right.
Come up preferably within a period of
1 month.
1 month
I will produce the certified.
from the
copy of-
date of copy of this order.
All right.
My lord, this matter pertains to treatment benefit, my lord, to the workmen of tea garden, my lord. Now, lordship in pursuant to order of this honorable court, the money has been disbursed to the 3 workmen, my lord. Actually, they were as per the union calculation. It was different as per management calculation, it was different. So under the payment of wages tax, the matter was decided. So initially, when we moved the writ petition, the court has directed us to make the payment to the employees.
Who are you?
I'm the garden, my lord, Grove Tea Company.
Okay.
And our garden is Inali Tea State, Dibrugarh, my lord. That is Nahar Katia, Dibrugarh. Now, my lord, so far 2 persons concerned, my lord. We paid the money, my lord. That is
Out of 3%, they are paid to 2.
2 person and 1 person died, my lord. Sanlata Barua. He died, my lord. So that's why we could not make the payment, my lord, to her. But I have been told that her son is there. So if he approaches the management with the legal document, then we will disburse that amount to. So-
So,
Now the question is that, my lord, with the MOU which was there in dispute, it's of 2013. By the time 4 settlement MOU has been signed in between, my lord. So the issue is, my lord, more or less it's dead type like, my lord. So there's no because we have paid the money, we don't want to realize that money also from the workman, right? because they all retired. The two person and third person has died. So Lordship may close the matter, my lord, that without that this will not become a precedent for any future case, my lord. That
But how much were you supposed to pay?
59,230.
To three workmen?
Three workmen, my lord. There is a
Yes, no, so divided by three will be how much?
DR Gogoi, 39,724. J Datta, 1,982.40. And Santala Bova, 17,507.52. So we, except that Santala Bova, we paid to rest of the
So Santana Parva is getting 70,000.
17,000. So Sun comes, if Sun approaches us, then we will make the payment happen. But we had filed an application at that point of time because we didn't find his legal heir.
Okay. Right. Heard Mr. J. Roy, Learned Counsel for the petitioners. And Mrs. A. Bhattacharya for
the workman.
for the workmen.
Workman is for the union member.
Huh? For the
Union. Union for the respondent number 2, my lord.
for the respondent number 2.
Assam Cha Karamchari Sangha.
Assam Cha Karamchari Sangha. Huh? Respondent number 2. Good, sir. The challenge in this writ petition is to the legality and validity of the order dated 12/11/2015 passed by the Assistant Labour Commissioner, some authority under Payment of Wages Act, 1936, Dibrugarh, directing the petitioner to pay a total amount of rupees 59,213 full stop 92 to 3 employees of the tea estate belonging to the petitioners in the following proportions. Where is that page?
Page, my lord, will be page 58.
Page
Page 58, last part, my lord.
Page 58.
The amount
In
is
the following proportion, huh? Now, so it's here. Page 58. 1, 2, 3.
Yes.
Huh? 1, 2. Okay. Next para. The Mr. J. Roy, the learned counsel appearing for the petitioner, submits that Shri Dhoni Ram Gogoi has been paid rupees 39,724, while Shri Jiban Chandra Datta has been paid rupees 1982.40. He submits that Srimati Sanlata Barwa could not be paid the amount of rupees 17,507,52, on account of the said lady having died
died on 2/11/14.
on 2/11/14. He submits that. Information, no, he submits that. It appears that Srimati Sanlata Barwa is having a son. This is what? Is having a son?
I mean, I have instructed, my lord, his name is Midul Das.
Don't say that. Don't say that. Don't say Mr. J. Barwa. Cut that much. Miss A. Bhattacharya, learned counsel for the respondent number 2, submits that Miss Srimati Sanlata Barwa has got a son, namely
Midul Das.
Midul Das, to whom the amount of rupees 17,507.52 can be paid. Mr. J. Roy, the learned counsel for the petitioner, submits that as and when Mr. Midul Das approaches the petitioner with proper identification and proof that he is the son of the late Srimati Sanlata Barwa, the rupees 17,507.52 shall be paid to the said person. Anything else?
My lord, the only thing, my lord, that memorandum which is under challenge is 13/1/2013. That is annexure 4, page 37. My lord.
Yes.
So that this should not become a precedent in future.
What is this memorandum of settlement?
This memorandum may not fixes the pay revision in respect of employee. Lordship may see this page 38, my lord. So
Yeah.
page 38, this pay scale, my lord, on the left is the old pay scale, and the right is the new pay scale.
So
So the point is that, my lord, the pay scale is adjusted point to point basis, but it is not open-ended. It's a close-ended pay scale. So they were asking for a pay scale which is beyond the pay fixation, my lord. That was the challenge between us and the
this
respondent.
is not, but then this,
My submission is that that objection may not be there
correct, correct.
without hearing the matter. So if they dispose of with that objection only.
But
Okay.
that we will not become precedent, my lord, because otherwise
It will not
we have to
be
undo the
precedent.
facts to my lord.
Huh?
Because that's what we are considering, my lord, because now there's a core a memorandum.
But this is not the issue in the writ
The
petition.
issue is this only, man.
Where is the, let us see the order, impugned order,
Yes.
what else?
Yes, lordship may see, page,
But without full hearing, my lord, no objection may be there.
Correct, without hearing, then I'll have to hear you.
it is, in the beginning, my lord, the case I in brief is that secretary, page 56, my lord.
Yes,
The Karamji Sangha Narkatia also is dated 3/4 of raise a complaint over arrest non-implementation of revised pay scale by the management of Sinali Tea State as per memorandum of settlement dated 13/1/2030. So this settlement is under challenge by them. And number
no, challenge by, no, it's not that, it's not under challenge, over non-implementation.
is non-implementation.
Non-implementation does not mean it's a challenge, he's saying
And-
that, why don't you implement?
Implement, that is one of that we say that is been implemented, and we have shown that how it is implemented. They want to say that.
No, because we
And
won't get,
next point is that, Manu, with regard to jurisdiction, we have challenged it, man.
we
that
won't go,
we
we
say
won't
that-
go into that effect.
In that matter. They correct.
We won't go into that.
Because-
I've got to have an entire hearing.
Or lordship may point out the jurisdiction part, my lord, because we have challenged the jurisdiction that payment of wages act is not the authority to decide the issue. It is the industrial dispute act, under the industrial dispute act 47, it has to be decided. But it was decided under the payment of wages act. So that point may be kept open.
Which point?
That the jurisdiction part. That payment of wages act is not the authority. It is the industrial dispute act, because if your lordship is a notice initial,
Yes.
the memorandum.
Now that, my lord, if that is so, my lord, your lordship is fixed there for hearing.
Your lordship may see the page 40, my lord, the same
You
memorandum.
see, if it's a consent order, if you have to give, the order and merit,
Because they have not challenged the subsequent 4 MOU which was signed.
then I'll have to hear you. I cannot go into, I cannot. I'll have to hear you on this point. How do I know how,
Lordship
what,
may say,
who
Lordship
will affect,
say-
how it will affect?
Lordship may say,
You see, this is a, this, this revised pay scale has been made by you.
no, as per that is as per that MOU, man, 13/1/2030. Lordship may then recorded one thing, my lord. In between, my lord, there are 4 settlements. So, Lordship says that after 2030, there are other settlements. So, they have not challenged that MOU subsequently. Rather, they should have challenged, but they have not challenged the 4 MOU. That becomes, the issue is become stopped there only 2013 only they have challenged. So, rather 4 MOU, they have not challenged. Okay. So in view of the payment, what my record is that, my lord, in view of the payment, the petitioner doesn't want to. The petitioner and respondent doesn't want to continue with the case. Lordship may.
Right, in view of the submissions made, in view of the present case being disposed of on account of the petitioners having agreed to pay the three workmen the amount as stated above, comma. The other issues which have been put to challenge by way of this writ petition have not been decided,
And
have not been decided.
and the respondent also agreed for that amount. Don't like my lord. That will help me.
And your lordship may fix a time period.
Uh, just prior to that, just prior to this sentence, it is right. The amount, the parties have, the counsel for the respondent agree. Respondent number 2 agrees that no further claim will be made by, in respect of the payment to be made by the petitioner.
And that payment should be made within 1 month.
The submit Tara, the end due, right? The no, as soon as he arrives, naturally. How can you say 1 month?
But
As soon as he might approach after 5 years, after 2 years, after 3 years.
So as and when the
It is needless to add that as and when the son of so and so, son of so and so, appears with all identity proof, certificate, comma, the money payable should be paid to him immediately.
public.
Writ petitions are accordingly, writ petitions accordingly disposed of. IAS, in view of the order passed in the main case, the IAS also disposed of accordingly.
Public. In any case, the respondents are not affected. It's a question of their reinstatement during the pendency of the case.
They have retired.
No, they have reinstated.
Every reason, they what remains?
No.
Back
The-
again.
The process is when an appeal is filed from the GI, during the pendency, they have to be.
Okay.
So in that case, we can impact it. Anyway, all that, but issue remains.
Okay.
If I succeed,
Right. On the prayer for adjournment made by Mr. R.K.D. Chaudhary, Deputy SGI, which is not objected to by Mr. A. Das Gupta, learned senior counsel for the private respondent. List the matter after,
Let the paper month of May.
list the matter after 4 weeks. Does it usually happen?